Dear ladies and gentlemen, it is with profound feelings of joy, and it is a special honor that I may introduce Dean Robert Cunningham to you. Throughout his professional career, Professor Cunningham has engaged with the law in his capacity as both a legal practitioner and an academic. As a legal practitioner, his efforts have concentrated on the provision of legal information, court advocacy, and education in a variety of capacities, including within community legal centers, legal aid, and the not-for-profit sector. He currently practices as a part-time barrister, concentrating on federal court matters within Murray Chambers. In academia, his pursuits have primarily focused on the manner in which the law interfaces with international trade, sustainability, corporate accountability, intellectual property rights, and information governance, and the latter is very much in the focus of today's edition. Professor Cunningham is both Dean and Head of Curtin Law School and a Fellow of the Australian Academy of Law. And as I said initially, it is both great honor and joy to welcome you in this context. So with no further ado, I'd like, dear ladies and gentlemen, to present Professor and Dean Robert Cunningham to you.
Great. Well, thank you so much for that warm introduction, Dr. Demetrius Perishu, and also congratulations on getting together this fantastic transatlantic legal lecture series. And as I was saying prior to the recording, it's one of the good things, I guess, about COVID-19 is that it potentially brings us closer together, even though all of these sorts of things were perfectly possible beforehand. We seem to now be much more au fait with the technology, and even simple things like trying to share slides and a screen aren't always that simple when you've got several screens and several things going on your computer. So I've been making my way through the technology at the beginning of this session. As Dr. Perishu said, today I'll be talking with you about information environmentalism, which is a book I wrote some years ago, but I'm still interested in presenting the work because in many ways it's established the foundation for me to go on and do other academic exploits. The most recent of which is what I often refer to as legal science fiction, which is to say, thinking about what might be happening in the future and trying to make up a set of facts or contentions that might arise in the future, and then trying to write mock legal judgments in relation to those facts. So what I thought I would do today is give you an outline of what information environmentalism is all about, and then talk to you a little bit about the way in which I've used that in legal science fiction to write, as I say, mock legal judgments. In this case, the judgment was in 2037, which sounds a long time away, and it is. And what you find when trying to predict the future is that it's a very dangerous pastime, and I'll explain what I mean by that when we get to that section of the presentation. So I probably don't need to convince scholars in this virtual room that there is nothing quite as practical as good theory. That is something that a quote that is often referred to by way of John Dewey, but in fact, I think Kurt Lewin was the actual author of that sentiment. And I guess the key point here, or the key word within that particular quote, is the word good. And as many of you know, it's quite challenging to construct good theory. And it's even more challenging to think about how good theory might be applied in the so-called real world. But in many ways, that's the excitement of academia, seeking to do just that. So As you know, many areas of law are essentially seeking to mediate between both private and public interests. And this mediation between public and private interests is not a new story. What I've found, though, is that intellectual property is a really useful starting point when thinking about private and public concerns, because since its inception in the 1500s, intellectual property has always sought to strike this balance between the private and the public. That is, in very simplistic terms, it's about incentivizing production and therefore producers, but it's also making sure that any production that does take place, whether that be creative production or industrial production, is done so in the name of the public interest or for the public good. So this balancing act between rewarding creators on the one hand with ensuring that society benefits from that creation on the other, as I say, has always been part of the DNA of intellectual property. But one thing that I think we should always be mindful of is that if we don't take conscious steps to look after the public interest, then it's often the case that private interest will come along and trump those public interests. And I use the word trump advisedly there. And so, you know, this balance between private and public interests will become increasingly important in the digital age. And of course, we're seeing that play out at the moment. So just in terms of the inspiration, I guess, for this research, the starting point for me with respect to information environmentalism was that I cared about the physical world, that is the natural environment. And in the 1990s, anyone that was concerned about the physical environment pretty soon ended up finding out a little bit about the international trade law framework, because there's a nexus, of course, between the global political economic system, if I can put it that way, and the health of the physical environment. And so, particularly with respect to what might be loosely referred to as the neoclassical agenda of free trade, that sometimes came into direct conflict with environmental outcomes. And so all of this got me interested in the World Trade Organization and more broadly the global economic architecture. And of course, an important aspect of the World Trade Organization framework is the TRIPS agreement, which is the trade-related intellectual property agreement. And it's useful to look at intellectual property from an international trade law framework because it's probably the most harmonized area of law in the world, which is not to say that there aren't important differences from one place to another, but certainly there is a level of harmony that you don't see with respect to other areas of the law. But from my point of view, the more that I learned about intellectual property rights, the more I saw a connection between the various struggles that existed to protect the physical world and the various struggles relating to what might be referred to as the overreach of intellectual property. And if we cast our minds back for a moment to the UK, the United Kingdom in the Middle Ages, and of course we could do the same sort of exercise throughout much of Europe, that was a time, of course, where the colonisation process was intensifying in the Middle Ages, such that the physical commons was increasingly becoming subject to privatisation. And this process has come to be known as the first enclosure movement. Like many periods of struggle, wars were fought, people died. There were ultimate conflicts between, again, private and public interests. And of course, if we fast forward from the Middle Ages to the end of the 20th century, we can speak of what might be referred to as a second enclosure movement, which could be characterized as denoting the contemporary colonization of parts of the information domain. And at the heart of this second enclosure movement is what's sometimes referred to as intellectual property maximalism, or more generally speaking, the overreach of intellectual property rights. And for any of you who have studied intellectual property, I mean, regardless of your political views, I'm sure that you can come up with examples where the intellectual property system has sought to overreach in some shape or form. And one of the examples that I like to quote is an example that came to my attention through Professor James Boyle at Duke University, where he talked about patent number 6,004,596 in the United States, which was essentially a patent for a peanut butter and jelly sandwich. And reading the exposition of that patent is very interesting, because it makes it sound extremely complicated to create a peanut butter and jelly sandwich. But of course, we all know that that's not quite the case. In Australia, we could talk about smoke bush, which is basically taken from the traditional knowledge of the First Nations peoples in this country. We could also talk about the ownership of turmeric in India. And there are many other examples of that type of intellectual property ownership, but also in a more general sense, the ownership of algorithms or the ownership of human genes. And of course, in the academic environment, we're all familiar with instances where we can't access a journal article that we've actually written ourselves, or a book that we've written because the intellectual property system either blocks us out or says that we're not subscribed to the right database. The point here, I guess, is that while ownership and property rights are important, and I'm not suggesting anything other than that, there are instances where property can go too far. We talk about the tragedy of the commons, but we could also talk about the tragedy of property rights, sometimes referred to as the tragedy of the anti-commons. But all of this is really just a springboard to flesh out the very simple point that there are conflicts and tensions between private and public interests. So in many ways, from what I saw, bearing in mind my interest in the physical environment, is that if we think about the environment as the ultimate public good, we often see a dynamic where benefits are privatized and costs are socialized. And so whether that's the pollution of a river or the pollution of air, all of society obviously bears the cost of those things, where more often than not, the benefits associated with that type of externality are privatized. So if we go back to the 1950s, there was no such thing as environmental law. We had political movements emerging in the 1960s and 1970s that shone a spotlight on various ailments in the physical environment, whether that was the decline in biodiversity, whether it was the beginning or emergence of what we now refer to as climate change, the pollution of rivers, the list goes on. And of course, those people that became activated in this space politically didn't necessarily sit down with a pen and paper and start theorizing about, what was the root cause of these problems. But I think if you reverse engineer from a theoretical point of view some of the concerns, you can come up with at least 4 analytical frameworks that provided the foundation for the political movements to protect the physical environment, but more importantly, for our purposes, the emergence of what we now know of as environmental law. That is, the body of laws seeking to regulate or otherwise protect and maintain the integrity of the physical environment. So without rehearsing in detail these four analytical frameworks, I guess if we just think about it from a takeaway point of view, what does welfare economics tell us? Well, in many ways, the benefits of economic systems are generally well understood, but the costs of an economic system are often hidden. And of course, we refer to these costs as negative externalities. And they're usually hidden because they're difficult to quantify or measure. The commons is interesting because it really gets us to think about the validity of property rights. Because in one respect, everything begins in the commons in a literal sense, and then it is subject to the process of privatisation or propertisation in some form or another. So the commons is a useful analytical framework, not just to analyse the commons, but to also analyse the flip side of the commons, which in simplistic terms is property rights. Ecology teaches us lots of things, and we have to be careful because everyone from Adolf Hitler to Kropotkin has used ecology in one way or another to advance particular arguments. And so we need to be careful, I guess, about the way in which we do rely upon ecology. But in simplistic terms, I think that it speaks to the importance of diversity and the importance of resilience. And those lessons about diversity and resilience can be applied to any system, not just ecological systems. So we can apply the same sort of thinking to social systems. And then public choice theory really speaks to the hazards of concentrated interests in shaping regulations. So if we think about climate change, for example, and the influence that big oil might have had on the regulation of climate change, then we start to understand the importance of the concentrated interests and the way in which they affect regulatory frameworks. And in some ways, when we're thinking about the regulation of information, we might argue that the information commons is the equivalent to the environment in the physical world. So really what information environmentalism is about is thinking what happens when we apply the theories that underpin contemporary environmentalism to the information domain. What lessons can we extract from the regulation of the physical world when looking at the regulation of the information world? And if we go through, and I'm just going to move through the four analytical frameworks now, starting with welfare economics. As I said, this analytical framework underscores that every economic system has costs and benefits, and we need to take into account both those costs and benefits when determining what to do or indeed what not to do. As you all know, I think economists will often refer to as negative externalities. And in the physical world, we see negative externalities in action all of the time, whether it's the pollution in the river. The negative externalities that play out in the information world can be just as damaging, but often more difficult to see. So, for instance, a classic negative externality that plays out in the information world is privacy violation. And we could think about or conceptualize privacy violation as being a type of information pollution or a negative externality that plays out in the information domain. So we don't need too much imagination to think about the power that's been accumulated by Google or Apple or Facebook by virtue of owning that information. And we can begin to see that type of privacy violation can really be thought of as a type of information pollution. Also, and I guess this is a little bit more abstract, but if we go back to Adam Smith and the Wealth of Nations in 1776, he made it very clear that information is an important part of any market operating. This is one of the reasons why we often have disclosure obligations, because there's market failure with respect to that. But also, information is a critical component of the capitalist system. And this is where intellectual property gets sort of interesting, because on the one hand, intellectual property often represents information that is important for the economic system to operate, but it's also a commodity within that economic system. So I often refer to what might seem like quite an outrageous example, but imagine that next time you go into the supermarket that you had to pay in order to find out the price of every item that you wish to purchase. Beyond being absurd, this would be an incredibly inefficient world to live in. But the example reminds us that the economic system relies upon a type of commons in order to function. In this case, we might refer to it as a price commons. And there are various gambling agencies and others that seek to actually own price. That's a story for another day. But just conceptually, imagine a world where price was not revealed in the commons, but was actually hidden behind paywalls. It would actually, as I say, not just be an absurd world, but it would be an incredibly inefficient world. And so that strange example highlights that the economic system that we live in does rely upon various commons in order to function. And in that instance, it's a commons that really relates to information. It's also important to note, I guess, that intellectual property rights seek to commodify information through setting up monopoly rights or a quasi-monopoly right. And these rights tend to lead to distributional costs. So if we think about a pharmaceutical company, for example, do they seek to produce drugs for tropical diseases that dominate in poorer countries, or do they spend their resources on drugs for lesser important issues in the first world? And I think we all know the answer to that. And that dynamic can really highlights, I guess, the distributional costs associated with setting up various property rights. And so in this respect, big pharma might end up paying whims to the wealthy rather than the needs of the poor. And we see that dynamic playing out in various ways. So that's welfare economics in a nutshell. If I just move now to the commons, I guess I'll go back to, in a sense, Roman law to make the contrast between res communis and res nullius. Res communis is, of course, a situation where resources belong to everyone. And so any use of that particular resource must be for the public benefit. And that's to be contrasted with res nullius, where no one actually owns any resources and therefore they are unclaimed and for the taking. And so res nullius is an approach that I guess has been supported by various colonial enterprise, because if resources belong to no one, and indeed Australia was a nation that operated under this doctrine for several hundred years, where basically the Constitution was built on the idea that the land was that belonged to no one, and no one actually lived here in the first place. Now, regardless of what your political views are around those processes, just from a factual point of view, it was not true that no one lived here, and therefore the doctrine of terra nullius was not factually correct. The point I guess I'm making here is that that the commons has always been a site of struggle, and again, it's a private struggle. It's a struggle between private and public interests. Again, if we go back to the Middle Ages, we'll often see what's called scattering, where property rights are not just an on-off switch, but it may be that that certain pieces of land are owned by one person or family at one particular point in time, and in another season, for example, that same piece of land might be owned by someone else. So it might be that there is the grazing of animals at a particular time of the year and the harvesting of wheat, for example. And so my point here is that property, although we tend to think of it as an on-off switch, often has much more grey areas to it. And so even if we're thinking about intellectual property, I mean, it's an old example now, but the fact that you can photocopy 10% of a book, for example, demonstrates that there is an aspect of a textbook that is part of the commons, and there's another aspect of that textbook that is really subject to private ownership. And so property rights are not, as I say, an on-off switch. So turning to the third analytical framework of ecology, there's several lessons, I guess, that we can take when we are applying ecology. The first is what I mentioned earlier, which is the importance of diversity and resilience. All of you, I imagine, would have used Internet Explorer at some point, as well as Mozilla Firefox, and they both essentially have the same function. But of course, one of those programs is made through a closed source model, being Internet Explorer, whereas Mozilla Firefox is more open. And what's interesting, I guess, about open source from a systems point of view is that it tends to support various attributes like decentralization, self-organization, and strong feedback loops. And we see that same sort of thing playing out with respect to many open source initiatives. And I mean, Wikipedia is probably oversighted, but you know, what is it about Wikipedia that makes it efficient? It's modular, it's granular, it's relatively easy to stick together. Those characteristics actually make it quite compelling from an economic efficiency point of view. And we can debate the reason why people might contribute to Wikipedia, but the interesting thing to note here is that people do it. And in a way, that mode of production creates and promotes some of those characteristics that I mentioned: decentralization, self-organization, and relatively strong feedback loops. The other lesson that ecology gives us is that it gets us thinking about allocating rights to intangible things. Now, we do this all the time. Corporations are intangible for the most part, but we allocate rights to them. Some of you will be familiar with Christopher Stone's work in the 1970s, where he was asking whether trees should have standing. And I guess what I've done in my work is to apply that idea to the information commons and to ask the question, should the information commons have standing and rights before the law? Now, in many ways, this is just tweaking what the general public license does, which is the open source license that underpins Mozilla Firefox and Wikipedia and other such initiatives. So what would it look like if we had a world where third parties could speak on behalf of the information commons or against some of the other information pollution examples I provided before, such as privacy violation? And I guess the third important point about ecology is that it's often used as a metaphorical springboard. So to extend the idea that I was just speaking of, might we speak of informational national parks? If we were to take this idea seriously, what information would we place inside an information national park? It seems like a strange idea at first, but of course I'm speaking the English language, and any idea that that language could be privatized, or indeed any other common spoken language could be privatized, is quite absurd. So in some ways, in an informal sense, we could say that the English language essentially does sit in an information national park of some description, and many languages might also, we could say the same thing about. I guess the issue is, as we move deeper and deeper into the digital world, and much of the relevant language that we might speak of is actually code language, the question of who owns that language becomes increasingly important. It's something that we haven't had to grapple with so much in the analog world, but in the digital world, it will become an increasingly important issue. So, as I say, it might seem fanciful, but even the general public license is in a way a quasi-private informational national park that is being created by virtue of leveraging the intellectual property system. And then the fourth and final analytical framework is that of public choice theory. As I said, climate change is a good example of how this particular theory plays out, because we see the effect of concentrated interests in essentially, I mean, particularly in countries like Australia. We've had a change of government now, but previously for many years, the Australian government had its head in the sand when it came to climate change, and that was largely because of vested interests that sat behind those regulatory frameworks. And so we can think about how those dynamics might play out in the information world with respect to Google and Apple and Meta and the like. But one thing that I find useful in this public choice theory domain is this political economic map. And like all maps, it's simplistic, but you've got control at the top, you've got freedom down the bottom, and then on the east, you've got unfairness, and on the west, you've got fairness. And all political economic systems are seeking to grapple with these tensions between control and freedom on the one hand versus fairness or equality and inequality on the other. There's much that we could unpack about this particular political map, but the reason I've put it up is to talk about the fact that most production that occurs in our world takes place within one of the four production modes. Now, it may be that there's hybridization between these four modes, so it may be that the state and the firm are working together, for example. But just in simplistic terms, all production falls within one of these four modes. And the important point here is that certain goods are best made according to certain modes. So if you want to manufacture an aeroplane, for example, it's probably the case that a firm is going to be the best way of doing so. Hence, Boeing as one example. If you want to build public infrastructure, whether it be a telecommunications network or road and railway network, then the state usually does a reasonable job of doing that. The market works really well when producing goods and services, particularly where there are low barriers to entry. So, markets work most effectively when we're talking about things like the growing of fruit and vegetables, for example, or a service like lawn mowing, where the barriers to entry are very low and there's lots of competition. Economists would talk about perfect competition. But social production is something that often gets left out of the picture. And this is something that Yochai Benkler has talked a lot about in his book, The Wealth of Networks, and other work. And if you think about it, the history of the world is essentially built upon social production. So we think about language, music, science, even law, has mostly been constructed through a social production framework. So my main point here in terms of how we might use that political economic map is to say that if we go back to the 1700s when Montesquieu was talking about the separation of power between legislative, executive and judicial, that was all very well in the 1700s and onwards, where most of the power was residing in the political domain, although that is a point that could be contested. But certainly as we moved into the 20th century, we started to see power amassed more through the economic form rather than the political form. But we haven't necessarily created the constitutional mechanisms to separate that economic power. We do have competition laws, for example, or antitrust laws that seek to ensure that economic power doesn't become too concentrated. But rarely do we look at those sorts of laws through a constitutional lens. And so my point here is that we need to actually think about applying the separation of power doctrine to the economic domain, not just the political domain. And so what that means is that we would essentially, from a policy point of view, you would want to encourage competitive tension between the four different production modes. So you wouldn't necessarily want any one of those four production modes to dominate, but you would want competitive tension between them, between what I would call the productive forces. So all of that leads to 12 governance principles that we might like to reflect upon. I won't seek to go through all of these now. I can share a 5,000-word article that summarizes most of what I've said today, and you can analyze it in your own time. But essentially what I've done is taken those four analytical frameworks, applied those analytical frameworks to the world of information, and come up with a series of what I call governance framework principles that we should be concerned with when thinking about regulatory frameworks. And so I guess, when I try and explain information environmentalism in simple terms, I use the analogy that I referred to earlier, where I say, if you go back to the 1950s, there was no such thing as environmental law. We had political movements, and then as a result, we had environmental law frameworks evolving both domestically and internationally. And what I would say is in the year 2022, we basically need to go through the same process, but with respect to the information world. So we need to look at information from a holistic point of view, and whether we're talking about misinformation, whether we're talking about privacy violation, whether we're talking about access to the commons, we need to make sure that we are looking at all of these issues from a holistic point of view. So I'll just finish off by referring to the ways in which I have made use of this particular theoretical disposition to engage in what I call future legal science fiction matters, which is to say, making up factual scenarios of legal contestations that might exist in the future and thinking about how we might resolve those particular contestations. And I guess I draw here upon the quote of Winston Churchill, where he says, the further you look into the past, the more likely you are to see further into the future. And what you find, I think, is when you do try and imagine what the future contestations might look like, I have found that it is actually useful to go further and further back into history to think about how those future issues might be resolved. So Roman law, for example, becomes a very interesting site for resolving tensions, whether it be res nullius versus res communis, or many other dichotomies that exist within the Roman law frame that actually provide useful touch points and springboards to flesh out these issues. So the particular case, which is all, of course, completely fictional, is the Commonwealth of Australia. We have the Minister for the Information Environment versus a company called Biodata Extraction and Excavation, Ltd. And this is a High Court case in 2037. So the starting point here is that we essentially have an intellectual property dispute between a big pharma company that is interested in extracting biological information for the pharmaceutical industry, and we have a conservation group who is interested in extracting biological information in order to conserve certain parts of the information world. So we have some cutting-edge virtual reality ubersonic technology, which basically allows you to put this technology on, and it allows you as a human being to taste, smell, sound, hear, touch, and indeed see biological information. And so it means that by virtue of going for a bushwalk, for example, with this particular technology, you can simply just walk through the bush, and by virtue of walking through the bush with this technology, you will be harvesting the biological data of your surrounds. But of course, the pharmaceutical company has different interests here, and it wants to make use of this information for its own purposes, i.e. to develop pharmaceuticals. And so a dispute emerges between the big pharma company and the conservation group about who can make use of, own, and otherwise exploit this biological data, which is being extracted by essentially a new piece of technology. So without going through the ins and outs of this particular judgment, what I did as part of this exercise is make up a number of international conventions and a few pieces of legislation that also evolved during the 2020s. So we had the Biological Data Mining Act, we had what's called the Global Information Commons Treaty, and we had an Australian piece of legislation called the Information Commons Rights Act, which set up third-party rights for groups to speak on behalf of the information commons. I then went on to essentially talk about a procedural issue and a substantive issue. So the procedural issue was whether or not the various parties had standing, and that relied upon the legislation that I just referred to, because the way in which the legislation was structured meant that the third party had to have an interest in some shape or form in the matter in order to have standing before the courts. And so that was the procedural matter. And then the substantive matter related to what is called the public trust doctrine, which some of you may be familiar with. But this really flowed from the US Supreme Court case of Illinois Central, which was an 1892 case, where the court disallowed the privatization of navigation waters of Lake Michigan because these resources were regarded as being held in trust for the people of Illinois. And so it meant that those particular navigation waters could not be subject to private ownership, but also private interests could not stop others from making use of what was essentially the public domain. So inherent within Illinois Central is a basic principle, which is that the public possesses certain rights in resources. And if you think about that from an information environmental point of view, then it allows the public to essentially rely upon those public possession rights in order to make claims to stop things from happening, or indeed to enforce other things from happening. So one of the key quotes in this particular case of 2037 is that access to and use of biological data, which is inherent within the information commons, is a fundamental human right that cannot be traded away by the state. So in other words, the state, in a sense, has a fiduciary obligation to look after the public interest when it comes to particular resources. And for that reason, as you might imagine, the conservation organization ended up trumping the interests of the big pharma company, and everyone lives happily ever after. So that was my attempt to take information environmentalism as a sort of theoretical underpinning, apply it to a future fact scenario, and, as I say, to write a mock judgment around that particular set of issues. So there's much more that I could say, but there's some further reading that you can find on the net, and I'm happy to provide some further readings if anyone is interested down the track. But essentially what I've tried to do today is just to give you a broad brush overview of what information environmentalism is by talking about the 4 analytical frameworks, which I say are representative of the sorts of theories that evolved, even if it's from a reverse engineering point of view, when creating environmental law throughout the 1970s. And I guess my key question is, how do we take the lessons that we might have learned when developing environmental law to protect the physical world, when thinking about how we might maintain the integrity of the information world throughout the course of the 21st century? So, Dimitrios, if there's questions or comments, then now might be the time to do so, and I'll stop sharing my screen.
Well, thank you very much, dear Dean Cunningham, for this very interesting presentation and this very fruitful, I'd rather say, lecture. I have to admit that I was particularly intrigued about the topic of the Information National Park, to be honest. If you imagine, for example, okay, I'm not neutral to that point, but if you imagine that one person would own the Greek language, for example, that person would be rich for sure. So, dear ladies and gentlemen, I do have actually some question, but I'd rather not want to start the discussion round. So if there are any questions, please feel free. Yes, Professor Oppermann.
Nobody else raises their hand. I'll try to do it, although I'm not so much concerned with environmental law. Nevertheless, I was fascinated by your presentation, Professor Cunningham. Not a question, just more a statement. Isn't capitalism general about privatization of the profit and socialization of the costs? So I think this model is pretty common in our world, and I agree, of course, in the sense of institutional economics, that is necessary to internalize these external effects in a sense for the market. Yes, but I did not understand completely the role intellectual property has in that sense. Information, yes, where you finished, because that property concept is a kind of thing we used very much in law of the 19th century. And there have been the great discussions about whether patent right or not is appropriate for the competition. You see, I'm concerned with competition a lot, so I'm interested in that aspect. If we compare it with other legal fields, like take securities, for an example, where in the 19th century it was very important to have property, industrial property, and such things to get credit. And nowadays it's more the assignment of future claims, of expectations. We are interested in, for example, in factoring or such a thing. So I doubt whether and your presentation sounds a little bit like that to me. I doubt very much whether such an extensive patent right ownership idea will be of any use for the future. That's the core of my question, I think. But as there is a general saying, predictions are difficult, especially if it's about the future.
Indeed. Yeah, look, I mean, it is true, I think, that the privatization of the benefits and the socialization of the costs is a common formula that exists. But I guess, you know, what I find interesting is that if we take the classical or neoclassical or neoliberal sort of points of view to their logical extension, we often find that there are some inherent contradictions, and that's where I was trying to go with those sorts of absurd examples about privatizing price, for example, because it's obviously a ridiculous example on one level, but it demonstrates that if you take some of the neoliberal doctrines to their logical conclusion, then you would privatize everything. But of course, even from a purely economic efficiency point of view, that would create its own problems, because it just simply wouldn't be efficient. And what I guess I find interesting, when you unpack neoliberalism, you strip away the actual ideology and you look at what's happening on the ground, what we see is that there are commons everywhere. You know, so we are relying upon a language that's essentially part of the commons. Much of the internet, as you know, is built upon the commons. There are commons every which way we look, but neoliberalism would have us believe that the commons is a side issue, or it's not really significant, and that really things need to be privatized in order to get innovation happening, in order to get everyone out of bed in the morning. But I guess that's where I find the work of Yochai Benkler really important, the wealth of networks, for example, because he just makes those points very simply, that particularly with respect to information goods, it turns out that capitalism, for example, is actually not very efficient at doing certain things, like creating languages, for example. Like the idea that we would only get out of bed in the morning to speak if we could rely upon the intellectual property system to protect the language that we're using is an absurdity.
Sure.
But of course, you know, that's the history of humanity, is that people have got out of bed in the morning to do a whole range of things, and even in the modern era, when it comes to Wikipedia and all of the thousands of other examples like that, they're not happening because of a strong intellectual property system or because people are getting paid. They're happening for a host of other reasons. And we could talk and debate about, you know, why it is that people contribute to Wikipedia, for instance. But the reality is they do. And the system works. And of course, Wikipedia is not perfect, but it's sort of an interesting, you know, if you sort of take your mind back to Encyclopedia Britannica and contrast it with Wikipedia, there's probably not a huge difference in terms of the accuracy of the information that's being provided. Encyclopedia Britannica was really a firm-based production model, whereas Wikipedia is a social production model. So I think from my point of view, I'm really interested in where the commons sort of hides in our political economic system, where it's, in a sense, not revealed as one thing, but going along with that is also the importance and significance of social production, because social production usually relies upon a type of information commons in order to function. And I mean, academia is a really good example of that. You know, where it develops on the basis of us having access to ideas and the like. So I'm not sure if I've adequately responded. There was one other point that you made about, you know, the role of intellectual property rights, and I guess my treatment of intellectual property rights throughout my presentation was superficial, in that I haven't sought to, you know, unpack the way in which intellectual property rights play out. But I guess in relation to that, I would just go back to that point that intellectual property rights are not all that different physical property rights, in that there are easements on property rights. There are a whole range of things that happen with physical property where it's not usually purely private or purely public. It's often a combination of both. And so again, if we're referring back to the neoliberal doctrine, which says, okay, you've got to privatize things in order to incentivize, well, it may be in certain instances that you need to do that. But even then, there will still be a commons element to what is being produced. So for example, with patents, yes, you might seek a particular right, but you're doing so on the quid pro quo that you lay open the invention. That's what the word patent, the word patent flows from the Latin term lay open, which is to reveal, which is to show the workings of your invention. So even in that instance where we talk about strong intellectual property rights, there is still an important commons domain, which is often left out of the picture or left out of the discussion or equation. So not sure if that's useful, but anyway, there's just a few more reflections there.
Thank you so much.
Yes, thank you warmly. Further questions, dear ladies and gentlemen? Well, in terms of matters of information pollution, which you also mentioned in your presentation, lately the European Union has issued, one could say, a rather huge digital package in order to, well, to say it politely, to take care of some internet giants and their contribution to matters of information pollution as you depicted them. It's fruitful, I'd rather say, also for us Europeans to get a view of third countries to that matter. And since the European Union has some sort of regulatory approaches, especially to whatever has to do with its internal market, do you think, from your point of view, that such regulatory measures can be helpful? So, in terms of avoiding further information pollution, or do you think that is something which the market itself could or should be able to take care of?
Yeah, look, it's a good question. I think this is where we do run into market failure in the same way that we have with the physical world, which is why, you know, we seek to either provide regulatory mechanisms or we seek to develop market mechanisms that essentially protect or maintain the integrity of, you know, the systems that we're focusing on. Obviously, talking from Australia to ostensibly Europeans, it's not my place to really talk about the importance of regulation in the digital domain, because I think Europe has done a much better job than most on that front. But the Australian Competition and Consumer Commission did create quite an aggressive inquiry called the Digital Platforms Inquiry in 2017, and I'm not sure if any of your virtual participants are aware of that. But I think the final report was handed down in July 2019. But it did, I think, quite a good job of pinpointing some of the issues with respect to the market failures that exist in this domain. It didn't necessarily come up with tangible and effective solutions to these problems, but it did provide the general impetus for the Australian government to take seriously the power of big tech and the way in which it is influencing our day-to-day lives. So, I think these things need to be done in a holistic way. They need to be done at a global scale. But it does require individual nations to go off and do some of the heavy lifting from a policy point of view to think about, what are the issues that need to be resolved here? Is it a regulatory story? Is it about, I guess, one way of coming at this would be to say that individuals own any information that they create. And you would therefore inadvertently or explicitly set up markets for information. And so if Google wants to harvest my information, they can do so as long as they send me a royalty check, in my digital bank account once a week or once a month, and then we've got a deal. And maybe, I don't know how people would feel about those sorts of things, but at least what it would do is make transparent the transaction, because at the moment, any idea that we are receiving a free service is a fallacy. It's just that, it's the costs are often hidden, which is, I guess, one of the points that I was making along the way in relation to welfare economics. So, I suspect that the answer is going to be a combination, in the same way it has been in the physical world, a combination of government regulation, international conventions, but also rethinking or reframing markets to determine, what role markets might play. But that's also where, the four production modes become relevant, I think, because from a policy point of view, if we can set up competitive tension between, say, social production and market production, it then gets us thinking about, well, what actually makes social production work? And as I said earlier, one of the things that makes social production work is access to the information commons. So if the information commons is diminished or polluted or otherwise loses its integrity, then social production opportunities will also diminish. And then the role that social production would otherwise play in creating competitive tension also falls away. So that's why I like to think of these things from a sort of, analytical framework point of view, to think, well, as a matter of first principles, how would you go about framing the policy settings? Because it's always going to be a combination of regulation and markets. But that doesn't really get you very far. You then need to take some further steps to sort of look at what that regulation might look like. What might those markets look like?
Thank you warmly. Dear ladies and gentlemen, any further questions to our dear Dean Cunningham here? Well,
being a Dean of Law, I'm very used to awkward silences, Demetrios, so I'm happy for there to be awkward silences for a minute or two while people formulate any further thoughts. But equally, if you want to finish up, then more than happy to do that also.
Well, actually, normally in my own lectures, I normally finish with the sentence, if there are no further questions, and normally quite often there are no further questions. I don't know why. So in that case, dear Dean Cunningham, I'd like to thank you warmly for your lecture today. It was most fruitful and very interesting, and it was, as I said initially, both a great honor and joy to welcome you in this context. So thank you warmly once more. Dear ladies and gentlemen, sorry.
No, well, thank you. And again, I was really honoured to be, if it's true, the first Australian to present in this series. That is a great honour for me. So very happy to do so. And I hope that we do have the opportunity of meeting in person. Certainly, if any of your virtual participants are in Australia, it's not the sort of place that you pass through accidentally, but if you make your way to the other side of the world, then I'd be very honoured to host you. And likewise, if I make my way to Europe, I'll be sure to look you up, and be good to touch base in person.
For sure. For sure. We will be in touch. Thank you warmly.
Inspiring. Thank you.
So, dear ladies and gentlemen, also a heartfelt thank you to you for your participation. And as always, as a conclusion, dear Andrea, thank you warmly for providing the online platform for this occasion. So once more, a heartfelt thank you to all of you and enjoy your day. Thank you and bye-bye.